Okay, let's start with this first lady. She is so sugary sweet that it's horrible to watch. And I feel bad for Judge Parker for having to go through it. He's going to tell her what's going on, and then he's just going to ask her some simple questions.
Ms. Peterson, I'm still waiting on one page of your paperwork, but I think I can kind of explain to you what your charge is based on what I do have. You're charged with criminal trespass. That is it looks like that's going to be a misdemeanor offense. The bond for that is probably going to be $1,500. I've got to read the actual warrant to make sure of that, though. But I think that's most likely what it will be. And also, that would include a provision that you can't return to that location where they say you were trespassing. And I don't have that address yet because that's the paperwork that I'm waiting on. But what I can do is go ahead and once I get that paperwork later, rather than having to have them hold you and wait on me with the paperwork, what I can do is just put that all into your paperwork later. If I read the warrant and there's any problems with that bond amount, if the bond amount should be different, or if there's any other complication about the stay away provision from that address, then I will reschedule for somebody to see you again tomorrow morning. But this will go ahead and let me get your bond order out today, so that if you're able to post bond later today, you will be able to do that. Okay.
Absolutely, Your Honor.
And do you want to apply? I'm sorry. What I'm also going to do is schedule your preliminary hearing for July the 18th, unless you want to waive that hearing. Do you want me to go ahead and put you on the calendar for July the 18th?
You know what, Your Honor? I am not a judge, so I let your discretion. That's your discretion, Your Honor.
Okay.
So I don't think I'm going to be watching this hearing July the 18th because I can't handle too much of this lady. I just can't.
I'm going to just put you on. Okay, I'm going to put you on the calendar for July the 18th. Once you talk to an attorney, y'all may decide to do something differently, or if you post bond and are released, then that hearing's just automatically canceled at that time. Okay. And then the other thing, do you want to apply for a public defender to represent you?
I'm going to let Your Honor choose him because I believe he's the best in the business.
Okay. All right. So let me just ask you a few questions to make sure you qualify. Do you currently work or have a job?
I don't believe so, Your Honor.
All right. Do you have any other kind of income?
All I got is this right here.
Okay. All right. So I'm going to find that you do qualify for a court-appointed attorney. And so I will put in the order today to appoint somebody to represent you. And like I said, I will get that bond order together. And if there's any difference in what I'm telling you, what I said, it looks like the bond amount will be $1,500, and that'll include a provision to stay away from the location where they say you were trespassing. But if there's any complication with that, I'll reschedule for somebody to see you in the morning. Okay.
You know what? I think you've got it down pat. I bet you've got some of the same memories I have, and I'm probably going to end up talking to this guy over here again.
I wonder if there's even a guy over there to begin with. But does the judge share the same memories as her? That would be interesting.
You done with her, Your Honor?
All right. Okay.
Thank you, Your Honor.
Thank you, Ms. Peterson. Have a good day.
Are you done with me, Your Honor?
Yes, ma'am. Have a good day.
God bless America.
Okay. So this next one, I mean, it's not the easiest one. It's a little difficult, but it's nothing major. Nothing crazy happens. But this judge, this whole court case and everything that's before it and after it is just, I don't know. It just was so entertaining to watch for me that I just let the whole thing in.
Hello.
I'm going to turn this down. Who's your client, Hillary? Who is your client?
Hey, Nathan. I have Danielle Willis.
Got it. Is Mr. Willis there?
It's Miss Willis.
Or Miss?
She is on the way. Should be walking in pretty soon, here any minute.
Thank you, Deputy.
She's in the shower.
I just read a news blurb, and I read it to Avis, where a woman shot her Uber driver in the back of the head because she started seeing signs that say Juarez, Mexico. So she thought she was being kidnapped. And she was in El Paso. Yeah, I'm glad no one's going to feel sorry for her there.
Yeah, no. Where was that, in Texas?
Yeah, in El Paso. Of course, I don't know how she won. If she flew there, how did she get a gun in the time that she flew there? She drove there. When you drive to El Paso, you see signs for Juarez or Chihuahua. There's all kinds of signs on the highway, even when you're in America. So,
Yeah.
Really, what's the backstory? She's not from Texas, is what I understand.
But you have to know, even if you're not from Texas, that El Paso's a border town. It's right on the border.
Yeah, and the little Uber
I would
app,
think most people know that.
well, the Uber app itself, you can track which map you're on and where you know where you are. I don't know. If only there had been another brave person in that car with a gun to stop it from happening.
Yeah. Because that's the solution, is more guns. Yeah.
Man, if Jerry's on vacation and doing this, we're all going to boo and hiss him. He better be in his backyard. Mm-hmm.
Trying to unmute. No, I'm well, sort of. We're turning into a bit of a vacation. My daughter has a softball tournament in Denver this week.
So you're not
At least
at
it's
home?
cooler.
Yeah.
Where are you?
Denver.
Oh, that's it. I'm canceling this
Not
hearing.
fair.
Ridiculous. Let's see. Denver. Is it going to break 100 today? I know it will tomorrow.
It's pretty warm right now. We're at the zoo.
Oh, you're at the zoo. Well, at least you're at a location where there's bars.
I mean, aren't all courthouses a little bit of a zoo?
Yeah.
And by bars, I mean imprisonment.
Yeah. They do sell beer here, though.
One of those fancy zoos with no bars. Oh, well, we're 3 minutes early, and that's what we get. I hope your phone lasts, Jerry.
Yes, sir. It should. It's fully charged.
Yeah, Zoom eats the battery. I don't seem to have Mr. Huseman's paperwork. I got the deal, but if that's okay.
And Judge Weaver, Miss Willis is in the shower, but we do have Huseman in here.
Ms. Notaris was first, but she shall be last. All right, Ms. Huseman, would you please approach?
Huseman?
Maybe she wanted to look good for her YouTube debut.
Yeah. Houston, we have a problem. Here he comes. All this man wants to do is talk.
Mr. Huseman, good afternoon.
Good afternoon.
My name is Walt Weaver. I'm the judge of Potter County Court of Law number 1. And it looks like you're prepared to plead guilty. I've reviewed the plea papers. But you also have a constitutional right to appear in my open courtroom and face your accusers, or you can also choose not to use that right as well. Are you agreeing to appear by video?
And what is this for?
This is for your plea of guilty, the trial for the assault causing bodily injury that you've been accused of.
Yeah, I'm guilty.
Okay. Do you see your attorney there, Mr. Morales?
Mr. Morales?
Right here.
Waving to you.
Hello?
Yes.
All right, then. Would you move forward a little bit? I'm having a hard time hearing you.
Yes, sorry, I just haven't slept in a while.
Well, it looks like you're getting out of jail today if this is the only
Awesome.
thing. All right, well, let's get started. The court now calls for trial, cause number CCCR-22-930-1. The state of Texas versus Connor Drew Huseman. What says state?
State's ready, Your Honor.
Thank you, Mr. Davis. What says the defense?
Defense is ready, Your Honor. Wavering the state's information.
Thank you, Mr. Morales. Good afternoon again, Mr. Huseman. Your attorney announced rate today for your trial for the Class A misdemeanor allegation of assault causing bodily injury. Were you aware that today is your trial?
Yes.
You read, write, and speak the English language.
Yes.
Barely.
Have you in the past or are you presently being treated for any kind of mental condition?
Well, I have like some type of imbalance, I know, because I overdosed. Like that was the reason. It's not the reason why I assaulted the person. It was literally.
Mr. Huseman, it was a yes or no question. If it's a yes, I'll explore what I need to know.
Wait, can you ask me the question again? Sorry, I'm really tired.
It's all right. Have you in the past or are you presently being treated for any kind of psychiatric condition?
Not currently, no, but I'm going to try to.
Are you on any meds?
No, I was on Risperdal.
There we go. It's a yes or no. Stop.
No, not right now, no.
All right. Are you a U.S. citizen?
Yes, sir.
Excellent. To the stated allegation, how do you plead? Guilty or not guilty?
I plead guilty.
Thank you, Mr. Huseman. Before I accept that plea, I do need to make an inquiry on the record as to your understanding of today's proceedings. Before me, I have the negotiated plea bargain agreement. Attached to it is a plea memorandum which reflects your signature. Do you recall signing the plea memorandums with the assistance of your attorney prior to today's trial?
Yes, sir.
Any questions about that document you may have had that Mr. Morales could not answer?
No.
Your signature tells me that you know that you have constitutional rights, but today you don't want to in exchange for the plea bargain agreement. So, for example, do you know what a jury trial is?
Yes.
Would you like a jury trial?
I mean, I'm kind of iffy on like knowing exactly.
It's a yes or no. If you want a jury trial, we'll.
What are those exactly like again? The jury trials.
Say it again.
What are those exactly like again? Like jury trials?
Well, you start the process with, I am not guilty. And that means the state has to bring witnesses in who testify under oath, and a jury listens. And the jury would decide if there's enough evidence. They could say there's not enough evidence, you're not guilty, or they could go, yeah, there's enough evidence, you are guilty. Do you understand the definition?
I don't think I have to go through that. I mean, I'm guilty. I shouldn't have punched the guy.
It's all right. It's a yes or no. Do you want a jury trial?
No.
There we go. Mr. Huseman, I think you understand your rights despite this conversation. I come to that conclusion because of the way we've talked back and forth. Your signature on the page, and most importantly, Mr. Morales' signature, which tells me you two talked about this prior to waiving your rights. I'm not going to read it all to you, but I would like to talk to you under oath about a few things. You have an absolute right to remain silent. You waived it by pleading guilty. You have an absolute right not to give evidence against yourself. You waived it by signing a judicial confession. No one can make you do any of that. But if I believe it, that's enough evidence at today's trial to support my finding of your guilt. Do you understand that?
Yes. Yes, sir.
Cool. Well, you waive the right to remain silent. Let me place you under oath so I can talk to you.
Okay.
Raise your right hand. Do you swear or affirm to tell the truth?
Yes, sir.
Put your hand down. Connor Drew Huseman.
I love this judge. Do you swear or affirm to tell the truth? That's it. That's all he does.
Did you voluntarily plead guilty? And did you voluntarily sign the judicial confession only because you are guilty and for no other reason?
Because I was guilty. So yes, I was guilty.
Excellent. Your risk at today's trial is up to 1 year in jail, up to a $4,000 fine, or some combination of fine and confinement. Today, however, you're saying, Judge, put me in jail 90 days, don't assess a fine, give me court costs, give me 43 days jail credit. This is time served. You have enough credit for your sentence and enough left over to pay your court costs. You're done. Did I announce your agreement?
Yes. Yes, sir.
All right, then. Anything about our conversation make you change your mind about your decision to plead guilty?
No, I'm not going to.
Connor Drew Usman, I find your plea has been made knowingly, intelligently, and voluntarily. Further, I find evidence sufficient to support a finding of guilt beyond a reasonable doubt, and I now do find you guilty of having committed Class A misdemeanor offense of assault causing bodily injury. Mr. Davis, anything in bar of sentence?
No,
Don't worry, this goes away in a
Mr.
second.
Morales?
Nothing in bar, Your Honor.
Nothing in bar. I have previously found you guilty. Connor Drew Usman, I sentence you to serve 90 days at the Potter County Detention Center. I will not assess a fine. I will assess court costs. I will give you 43 days jail credit. This is time served, meaning you don't have to sit in jail anymore and you don't have to pay any money. Mr. Usman, I did what you asked me to do. Would you like to file a notice of appeal complaining of a mistake or an error?
No, sir.
Would you like a new trial?
No, sir.
Thank you. What questions do you have?
You mentioned something about 90 days. You said that I didn't have to do that. Like I'm already done with my time.
Correct.
Okay. Yes, that's good. I have nothing further to say.
Excellent, Mr. Houston. Mr. Davis, any other matter before the court?
No, Your Honor.
Mr. Morales?
No, Your Honor.
Thank you, Mr. Morales. I see that you hit your spot perfectly as the film director told you to, because there's blue tape above your head. So, good job. Court's adjourned. Good luck. Give a fingerprint.
Thank you.
Have fun with the animals. Now some conspiracy person is going to say, did you see that mistake? They left the tape there. It wasn't accidental. Great. I've already appeared in some video that I didn't erase my YouTube quick enough. So, good. Is Miss Willis there? She done with her shower?
Yeah, she's here, Judge.
All right, Miss Willis, please approach.
I love this judge.
Miss Willis, good afternoon.
Good afternoon.
I need you to get as close as you can to that table and stand to your left where the microphone is.
Okay.
Miss Willis, good afternoon. How are you?
I am okay.
Much better. Miss Willis, my name is Walt Weaver. I'm the judge who's going to hear this matter. It appears to me you're prepared to waive a lot of your constitutional rights. However, you have a constitutional right to appear in my open courtroom and face your accusers, or you could choose not to use that right as well. Are you agreeing to appear by video today?
Yes, sir.
The court now calls for trial cause number CCCR-22-577-1. The state of Texas versus Danielle Grace Willis. What does the state say on her motion to proceed?
State's ready, Your Honor.
Thank you, Mr. Davis. What does the defense say?
We're ready, Your Honor. We'll waive reading of the motion.
Thank you, Mr. Tardis. Ms. Willis, your attorney just announced today for your trial where the state's going to attempt to prove you violated your terms and conditions of probation. Were you aware today is your trial?
Yes, sir.
Do you read, write, and speak the English language?
Yes, sir.
Have you in the past, or are you presently being treated for any kind of psychiatric condition?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Ms. Willis, what the state's got to do today is prove you're the one and same person who pled guilty. After you pled guilty, explain the rules to you, and then you broke the rules. I don't have to find all the violations to be true, just one to go to the punishment phase. Now, none of this is binding on me. Unlike your original plea and motion to proceed, whatever agreement you have with the state, I don't got to follow. But here's my agreement I will tell you that I'm going to have with you. If I just think I'm not going to do this plea offer, I'll let you withdraw your plea of true. We can start all over again, and you can bring in witnesses. And while you have no burden of proof, maybe these witnesses, through their testimony, would make me understand why this is the right thing to do. Do you understand that?
Yes, sir.
So there's no risk today. I'm going to talk to you. Either you're going to give what you want, or we're going to start over. With that being the case, since there is a plea bargain agreement, what I want to know is, will you waive your right to remain silent? Let me place you under oath and have this conversation with you so that the state doesn't have to call in witnesses. You understand that?
Yes, sir.
If at any time you need to consult with your lawyer, just tell me. We'll create a little telephonic attorney room, and you can have a private conversation. Do you understand that?
Yes, sir.
Will you waive your right to remain silent? Let me place you under oath and talk to you for a bit.
Yes, sir.
Raise your right hand. Do you swear or affirm to tell the truth?
Yes, sir.
All right, put your hand down. Are you the same Danielle Grace Willis who on December 6, 2022 pled guilty in cause number CCCR-22-577-1 to the accusation of assault causing bodily injury?
Yes, sir.
I don't know why I disappeared, but I disappeared. I didn't touch it. I was holding the plea papers.
Sure, Judge.
At that point in time, it appears that I didn't find you guilty, but instead, I placed you on deferred adjudication probation without any sentence. Is that correct?
Yes, sir.
Shortly after you were sentenced or pled and given deferred adjudication, were the rules and conditions of probation explained to you by a probation officer?
Yes, sir.
All right. What the state has done since then, they're alleging you violated your probation, and they filed what's called a motion to proceed, which lists and gives you notice of the accusation. Now, either you were served with a copy of this, or you have discussed with your attorney what these accusations are. Have you done either of those two things?
I don't recall.
Did you have a conversation with your lawyer about, is this true or not true? Did you break the rules? Did you use marijuana?
Yes, sir.
Okay, that's what I mean. It's nothing formal. It's not a PowerPoint. It's conversation. So what I need to know from you is the accusation true or not true? And remember, I don't got to find them all, just one. So if it's not true, just tell me.
It is true.
Well, I haven't read anything to you yet. So is it true or not true that you used marijuana on or about December 13th, 2022, and confessed to it to a CSO, Aaron Harmon?
Yes, sir.
True or not true?
True.
Did you, is it true or not true that you used marijuana on or about December 9th, 2023, and told your CSO, Rachel Cortez?
True.
Allegation C, that again you used marijuana on or about 5/14/2023 and 5/16/2023 and told Rachel Cortez again. Is that correct?
Yes, sir.
And I should have said true or not true, so it's my fault. True or not true?
True.
Excellent. Now, it also says you violated condition 11 that requires you to submit to a drug and alcohol evaluation and complete successfully the substance abuse treatment program, aftercare, AA attendance, whatever they required of you. Did you fail to complete the drug offender education class as recommended? True or not true?
True.
All right, good. And all these allegations, they occurred after the rules and conditions of probation were explained to you, correct?
Correct.
All right. Ms. Willis, I find that you made your plea intentionally, knowingly, and voluntarily. Further, I find you're the same person who made that plea, and as such, I'm also finding that the terms and conditions of probation have been violated, and I'm going to find that the evidence at the initial plea was sufficient to support a finding of guilt beyond a reasonable doubt, and I now do find you guilty of having committed Class A misdemeanor offense assault causing bodily injury. What is the plea offer, Mr. Davis?
I believe, Your Honor, it's 75 days in jail, which would be time served for Miss Rose.
I got 60 days. no fine, court costs with 25 days jail credit. So she can get time served for that and have enough left over for court costs. That's what it says on mine. Does it sound like it could be that?
Yes, Your Honor.
Okay. Ms. Notardas, is
Yeah,
that your...
Yes, and it just must not have gotten updated on TextShare, but that is what Amanda and I had discussed.
Excellent. And finally to you, Ms. Willis, is that your plea bargain agreement?
Yes, sir.
I told you if I wouldn't follow it, I'd let you withdraw it, but I am going to follow it. And therefore, having previously found you guilty and now sentence you to serve 60 days at Potter County Detention Center, I will not assess the fine. I'll assess court costs, giving you 25 days jail credit. This is a time served sentence, meaning you have no more duty to sit in jail with enough credit to pay your court costs. Ms. Willis, I did as you requested. Would you like to file a notice of appeal complaining of a mistake or an error?
No, sir.
Would you like a new trial?
No, sir.
Ms. Willis, what questions do you have for me?
None that I have at the moment.
All right, then. Well, my daughter's name is Grace. I just had this power right now. All right, Ms. Willis, thank you for working this out. Mr. Davis, any other matter before the court?
No, Your Honor.
Ms. Notardis?
Nothing from the defense, Your Honor.
All right, then. Good luck, Ms. Willis. Please give a fingerprint to the deputy. Have a good day. Court's adjourned. Are we done?
Hey, Judge, I was going to tell you, Kenna is the new 320.
So I stopped it there. There was a little bit more, but this judge has a nice sense of humor. Just everything about him is he's sort of like Middleton, but he makes more jokes. And the next joke that he made wasn't probably good, so I cut that out. But this judge, Walt Weaver, is great. Okay, so the next one we're going to, the lady wins, and I guess understandably she's not quite happy with the outcome, but she wins. She wins anyway.
All right. Well, this is recalling case number L2230685, the Lakes Apartments versus Alyssa Triplett.
Good, afternoon, portion here.
All right, Ms. Triplett, your name?
Elisa Triplett.
All right, so this matter is scheduled for bench trial today on a non-payment of rent matter. Ms. Triplett had indicated before you got here, Mr. Worker, that she had tried to contact your offices and no one ever returned her call to try to work on, to see whatever the issues are that are in contention. I guess to try to see if she could work it out or get an understanding of it. And she said that she had paid some monies. She had a different figure, $49.50 last time we were here and 22 cents. I guess, I don't know. You said $6,450. She wanted some more late fees waived. She said she wasn't late previously and she was locked out of the portal and couldn't get her payments in. And then she said something about some rent plus 5%. I don't know what that was. She thought, well, I don't know if you said it was $49.50 after the $1,500 that she paid was credited. She thought it was something like $13.10.
Sorry.
Or I could have that wrong, but at any way, there was some point of contention there. So, where are we, Mr. Ward? Can you discuss this with her?
Yes, sir. I spoke with her attorney this morning. I believe it was just.
Who was that? We don't have it here.
Mr. Hines. I have the information legally.
Who did?
Mr. Hines. With his lack of filing an appearance and nobody from Lakeshore being here today, my assumption would be that they were limited scope representing for negotiation only. However, he did not indicate that to me.
Okay.
He did indicate, however, that he would not be here. So we tried to reach a resolution in the form of a conditional dismissal. However, my client is not willing to waive any late fees. There are late fees that are charged under the lease, and position of my client is that the payment of rent in December, while it was on the 5th, technically timely, it did not pay her entire balance. She had an $80 balance. Any amount over $50 in somebody's ledger accrues a late fee, and late fees are charged, again, pursuant to the lease. They are $175 a month. In the case of Ms. Triplett, that is 10% of her rent after the 5th, 6th, and an additional 5% on 16th.
How many months of late fees?
There are 6 months of late fees.
All right. Okay.
If I could change that, I apologize. 7, if you include, she was charged late fees in December. So her current balance to date, we end up with 7 charges of $175.
And what's the current balance still?
$6,467.12.
Well, that's what they're contending, $6,467.12. So now I guess you can understand where they're coming from.
Okay, Your Honor, so I presented, I emailed the apartments, I have emails to back it up. I emailed Mr. Hyde, I have emails, not Mr. Hyde, I'm sorry.
Borkin.
Mr. Borkin, and this is what I was initially getting at. I was never late initially. They sent me to eviction wrongfully. This is showing, this all comes from a December payment that was paid on December 5th. It was paid. They told me it was never paid on time. My late fee.
Did you show them that today? Did you see that?
I did, Your Honor, and as I indicated, she did not pay off her given balance with that payment.
So there was a balance before that?
There was not a balance before that. My rent is $12.85 a month, and it shows on the ledger here. $12.85 a month. I don't know if you want this, you can go through.
Well, I'm not trying it just yet.
So it's $12.85.
Present me evidence. I'm just trying to see if you all can work it out, but apparently you can't.
Well, I just wanted to go through this. It's $12.85 a month, okay? And then I pay my water bill is $70. Okay, I paid them $13.70. And you saying there's a balance, where did the $80 come from? That's what I'm saying. I paid $13.70 as it shows on here. So.
And you didn't have any charges for the prior month that spoke over?
No, ma'am, because I wasn't late. I wasn't late for November either. It shows on the ledger.
Is that your ledger? Did you look at that with her, Mr. Morgan?
Your Honor, if I could amend my statement, it looks like the late fee was charged on the 6th. Her check is dated the 6th. So she actually would have had a.
No, it's dated the 5th.
Excuse me.
On the website.
Excuse me. She would have had a negative $20 balance if she had not been charged the late fee on the 6th.
Okay. So then was she late the next month?
Yes, Your Honor. At that point, there were
Forget the fact that she had the late
yes,
fee.
right.
When she would have been
January to date, there have been no. She has incurred late fees every month, and that is because she has continued to accrue balance. So the late fee in January was assessed. She made no payments in January.
Is that right?
This is what it goes back to December.
But ma'am, you had to make some payment.
Okay, so let me explain. So I was never late for December. They never sent a letter on my door. There was nothing because this shows I made my payment on time. Ma'am, what I'm saying is, Your Honor, I paid my rent on time for December.
I understand that.
Okay, so when January rolled around, I went to go in and pay my payment. They refused to take the payment because they told me that I didn't make my payment on time for December, and they assessed me all these late fees, and I was never late. That's the whole
Okay, I don't understand. She's saying they didn't even accept the payment. Why would they not accept the payment even if it was late?
So remember, when she tried to pay a portal, it was locked if she didn't pay her entire balance. So
But she's claiming she didn't have the balance. That's what she's claiming.
The portal is only locked if they have a balance in their trial. Well,
Obviously, we're not gonna work it out without a trial, so call your first witness. Make your own extend and call your witness.
Okay, here we are. The judge says, call your first witness. That's standard. That's what you do in court. You call your first witness. Here we go.
This is the trial.
If I can have a moment to get my witness, I would.
No, they're supposed to be here. This was a trial date. All trials are in person.
I then would stick to my testimony and
You can't testify.
well, I'm sorry, my statements regarding my business records of my client.
Well, you can't get the business records in if you don't have a client. All right, they're not there. I'm gonna decide the case. They can write it if they want to. Yeah. Rewrite this case. So it's not technically over. I'm just missing because they're not ready today.
Your Honor, there was a motion to stay that initial, that this proceeding on. This is not a typical. She paid an escrow.
I thought this was a trial date. I don't see no motion to stay. There's no judgment here. So how can it be a motion to stay without a judgment?
She indicated that she paid an escrow.
You requested that I do pay the escrow during the Zoom. And your Honor said she has to pay $3 something today prorated, and then, for Jill, she has to pay $13.10. I have both of my receipts showing that I have paid escrow.
She did. Okay, yeah. She did. What's the problem?
I would ask the penalty be released to plaintiff.
Well, that's what it's for. We'll do that.
Your Honor, if possible, if we could just set this aside for a moment.
Listen, I'm done. If you all want to resolve it, you got plenty more time.
We all know when a judge says, I'm done, they're done. It's over.
To do so.
Your Honor, I have one other thing. I received money that they're waiting on a check for $3,800. So that's gonna surpass what I owe, and actually my money escrow.
Ma'am, I don't have anything to do with that. I'm gonna give them the escrow, because that's what the escrow is for, is to secure the plaintiff while we're waiting to try the case for possession judgment.
So how do I get my money back?
You don't. That's what the escrow is for. Now, if they bring you in a court again, and you claim that this pays overpaid, then fine, or I guess you could bring them to court.
To me, it's like, this is my situation.
Ma'am, I have had no proofs here.
I showed you proof that I was never late. This is why they sent
This
me
is a
to
trial date. No one has tried the case. They have gotten the case dismissed because they don't have a witness present. That's what would happen if he didn't show up anyway. And the escrow would just go back to them. Because this court is to secure, the reason for escrow is to secure the plaintiff for protection. They claim they are owed $6,000. You said they owe nothing. They said you didn't pay in January, but you apparently didn't. I don't know why, if it was locked or what. But there's some kind of balance. I sure do, and I'm not sure what, because I haven't heard anything. You say zero, I'm not sure what it is, because I haven't heard any evidence. They haven't brought any evidence. That's why I'm dismissing the case. You all are gonna be in a position where you're gonna still work this out. Because if you're still gonna stay there and if you wanna move, I guess you can do that.
They refused to waive the fees that I never incurred. That's all I asked them to do, and I was gonna pay the rest. That's the only thing I asked to do. Take off the fees that I never incurred.
You can talk about it today, and if they want to.
They won't budge.
If they wanna agree to that, rather than refiling the case, they can. They can do that.
I don't even have this time to keep coming back to court with these people. And they know they were
Well,
wrong.
you just move. Then you won't have to deal with it.
Because I don't want this on my record. I'm trying to buy a
There
house
is
now.
no record. The case is dismissed.
And I'll talk to my client and let them know the circumstances. Your Honor, I do apologize for our lack of a witness today. I understand the court's position. It was something that we weren't prepared for today because it was in negotiations until so late. And it was supposed to be a position of dismissal, but we should have been prepared to that.
I understand.
And may I say initially, in our initial conversation on Zoom, You said the late fees are excessive, they're 5 times the amount. He
Now, if
said,
I went to trial and I made a determination, and I we would have reduced the late fees down to something a little bit more reasonable. If it was warranted that there were late fees due, I don't even know what was due because I don't. I haven't heard any
I
evidence.
know how much is due.
Ma'am, just like you know what's due, he says he knows what's due. That's what a trial is for. To present the evidence to some neutral party, me, who doesn't know what either of you are talking about, but I hear the evidence and I make a determination who's right. We didn't do that because they're not right. So you win because the case is dismissed.
So I don't owe them any money.
I don't know what you owe. It's up to them to determine if you do, and if they want to refile a case saying you owe some amount, then you be back.
I'm stressed to I have to wait for my life. I'm stressed out. I'm on medical leave because of this. But nobody's listening to me. I just rather just get this out the way. They won't budge. Period.
Well, I can't make them budge on their position. That's just negotiations and.
So this isn't gonna go on my record, is it, as a judgment?
Listen. Dismiss.
Okay.
No judgment, no case exists anymore.
I'm just stressed out.
I just want you to understand,
Okay, thank you
there's
for
no
verbalizing that for me.
case that exists anymore.
Thank you,
It's
Your Honor.
over. So no, there is nothing on your record other than this case was dismissed, filed and dismissed.
Thank you, Your Honor.
So you probably need to go back to your management and say, look, you got the escrow. What else do you say I owe? Because I'm not going through this again and I want to work this out. Or I guess you can move. I don't know what else to tell you.
Okay, thank you, Your Honor.
So there we go. There's our 3 court cases that kept me entertained for a while, so I thought I would share it with everyone else. If you've made it this far to the end, and if you don't mind, hit like and subscribe. It really helps a newer channel like mine. And the issues, it's bumpy the first time you live stream. It's way more difficult than you think to get these videos. Well, it's like fishing. When you get these videos, you watch the courts. And, sometimes you reel in a walleye and sometimes you reel in a catfish. But, after you find the videos, you think that's all you have to do. But nope, you have to have all these different softwares working correctly with YouTube to be able to stream. So this was my first one. So I actually just did it privately. And I think it went okay. It wasn't great. It wasn't terrible. So I'm going to post this to my channel. And if you see it, hit like and subscribe, and so I can keep doing this and get better cases for you guys.